Kim, are they ready on cure?
Yes, you have plaintiff in the movement.
Okay, you can let them in. Good afternoon, Mr. Smansky.
Good afternoon, Your Honor.
Mr. Sala.
Right.
Okay, Ms. Clifton, when you're ready.
This is case number 250094111CK, Cure DBA Cure Auto Insurance versus Howard Jack Bay et al.
Council appearances for the record.
Good afternoon, Christopher Saleh on behalf of the plaintiff Cure.
And good afternoon, Your Honor. Rick Szymanski for defendant MAIPF.
Okay, thank you. This is MIPF's motion to get out in lieu
That's
of an
correct,
answer.
Your Honor. We filed
Mr.
this
Smansky.
motion for summary in lieu of an answer on this case. I think the facts are pretty well laid out and pretty simple, as is our argument. So just to be brief, plaintiff's complaint alleges that defendant Jack Bay was involved in an accident on August 4, 2024, while he was operating his own 2022 Nissan Rogue that was insured with Cure. Cure, of course, has filed this deck action seeking to rescind that policy and have it void ab initio. And so it's the MAIPF's position that in any way, MAIPF cannot be responsible for Jack Bay's PIP benefits because either Cure will be responsible for payment of those benefits as his insurer, or if the policy is rescinded, he will be the owner of an uninsured vehicle involved in an accident and ineligible for benefits under 3113B. I'm sure the court's familiar with these arguments, and I know we have argued these with plaintiff before. So I would just quickly address that. I think the reliance on the Moda Peguero case misses the mark. That case had to do with rescission of a policy and whether or not the insured's medical providers could go back to that insurance policy. It had nothing to do with benefits under the MAIPF. And so I think it's wholly inapplicable.
Okay. Mr. Sala.
Thank you, Your Honor. So this issue kind of like splits into like the named insured and the medical provider. In regards to the insured themselves, I mean, the rescission doesn't alter the past to render the driver uninsured. The Supreme Court stated this in a case called Wilmore Moody v. Zakir. It's from a 2023 case where the Supreme Court held, quote, while rescission is a legal fiction available as a contractual remedy for the defrauded party, it does not alter reality or act as a DeLorean time machine. In sum, rescission of an insurance policy is a contractual remedy between the insured and the insurer. It does not operate to alter the past by rendering the insured as having been without no-fault insurance at the time of the accident, end quote. So that's in regards to the to Howard Jack Bay himself, Your Honor. But then for the medical providers, it's a straightforward issue because they're no longer in a derivative position, which is something that is fundamentally wrong in the MEIPF's motion. Their motion states that, I mean, if if defendant Jack Bay is not entitled to PIP benefits, then the medical providers would also not be entitled to benefits from the MEIPF either, because this derives from the fact that they stand in the shoes of claimant, but they don't stand in the same shoes as the claimant anymore, Your Honor, because the Dawood v. State Farm case that they rely on from 2016 is no longer good law. It's no longer good law because of that 2024 Motopagura case that we cited in our response to MEIPF's motion, Your Honor. That case held that medical providers are no longer in a derivative position to seek benefits. It appears that in opposition to our Motopagura argument, Your Honor, they have cited to Central Home Healthcare v. Michigan Assigned Claims Plan in the reply brief to our response. What I'd like to note about the Central Home case, Your Honor, is that there was no rescission involved like there is in this case, Your Honor. So the Central Home case involved a woman named Sandra De La Cruz who had a 2007 Chevrolet Suburban on her policy, and then she took off the PIP coverage off of her policy. So she took the PIP coverage off of that vehicle, which is the vehicle that she had gotten into the car accident in. There was no rescission whatsoever involved in that case, though. And if I could direct Your Honor's attention to footnote 5 of the opinion of the Central Home case I'm referring to, it specifically discusses that they're not applying Motopagura because It isn't a rescission case. In rescission cases, motor progrera does remain good law, and the medical providers are no longer in a derivative position. If we look specifically to the statutory exclusion that the MEIPF relies on, it's MCL 500-3113B. It states that the person was the owner or registrant of a motor vehicle involved in the accident. It does not say that medical providers are excluded. It is talking about the owner or the registrant of a motor vehicle. But if you look at the statute 500-3112, it provides a direct cause of action for the medical providers. So medical providers are not excluded under 500-3113B, and they do have a direct cause of action under 500-3112, which is why the court's decision in that motor progrera case found that medical providers are no longer in a derivative position, because the framework of the No Fault Act puts the medical providers in a non-derivative position.
Okay, let me stop you there. If they're in a non-derivative position and they can initiate their own action, how does that the fact whether or not there was a rescission affect them? What is your position there?
So you're saying if they're like if the court grants the rescission, Your Honor?
Right, yeah, if let's just say I grant the rescission, where are they getting their right to sue if the court enters a rescission? Because I I don't want to put words in your mouth, but one thing that I'm thinking about is a situation where you have an innocent third party. And sometimes with innocent third parties, their claim is allowed to survive with the MAIPF if in fact they are deemed to be an innocent third party. I don't know where that puts the providers.
So I understand where you're coming from, Your Honor. The right that you're talking about where the medical providers have a cause of action comes from MCL 500-3112. I mean, the statute in itself provides a direct cause of action for medical providers. It specifically states that healthcare providers can make a claim to the Michigan Assigned Claims Plan. Now, if the rescission is granted by this court, then the medical providers will be in a position where they won't be able to seek benefits from cure because of the rescission. So when you mention innocent third parties, cure in itself would be considered an innocent party in this case, because if the rescission in itself is granted, then the court is acknowledging that there was fraud within the application of insurance in which cure should be.
Okay, but I guess I was playing devil's advocate, and I'll let Mr. Szymanski chime in too, because we know that generally speaking, if you got an innocent third party, then their rights may survive. But here we're talking about a provider. Mr. Szymanski, you want to respond to that?
You're right, Your Honor. Their rights may survive as to cure. The MAIPF is statutory benefits. There's no balancing of the equities to determine who's an innocent third party. Equities don't come into play. It's just not an issue here. And I think that's what plaintiff's problem is. They're confusing statutory benefits with contractual benefits. Absolutely, by all means, those medical providers are entitled to a balancing of equities to determine if cure's on the hook to pay them, not the MAIPF. If we say, hey, insured, you can lie to your insurance company all you want, and if you get in an accident and you make a claim, the insurance company is going to rescind your policy, but it's okay because all of your medical providers and your attending care providers and your replacement service providers, they can all go to the MAIPF. What's the point of having an insurance policy? Mm-hmm. That would mean the MAIPF would be on the hook for everything, and it would basically render 3113B meaningless. It would have absolutely no teeth. And that's what I think we're getting into here, Judge. Again, the Motor Pagero case deals with balancing of the equities. It's entirely nonsensical. Just because a medical provider has their own cause of action under 3112 doesn't mean they're entitled to PIP benefits. Mm-hmm. Those are still connected to the injured party. If we found out that Mr. Jack Bay stole a vehicle and got into an accident, his medical providers couldn't come to us. If we found out that he wasn't a Michigan resident, his medical providers don't get to come to us. And so there's a disconnect here between having an independent cause of action and there being PIP benefits available. And in this case, there's just no way you get to come to the MAIPF. I would point out that the Wilmore Moody case was not addressed in plaintiff's brief, but I'm familiar with their arguments. I would just point out that was a very, very, very narrow ruling that only dealt with whether the insured could seek bodily injury claims from another insurance company. The court in that case specifically said that injured party would not be entitled to PIP benefits. He could go seek BI claims, but he's not entitled to PIP benefits. So I think it just misses the mark.
Okay. Well, taking that into light, most favored non-moving party, the court finds that one, as we've discussed, the impetus behind the MAIPF is to provide statutory coverage for individuals who are not otherwise legally entitled to benefits. And here we have some discrepancies here that may have to be borne out with the contractual basis, but not on a statutory basis. Yes, the providers can have their own direct cause of action, but their direct cause of action still must be consistent with the statutory constructions and the case law that's applicable in this particular case. But that being said, at this point in time, the court doesn't find that the MAIPF is in the position in any way, shape, form, or fashion to be the insured due to the fact that you have the coverage. That's where we have to stop. There is other coverage, and whatever happens with the other coverage, that's for the the insurance carrier, not for the MAIPF. So that being said, but one thing, I will dismiss it without prejudice. Okay. Unless there's something else that comes up that's a basis. But at this point in time, I'll grant the relief and dismiss MAIPF without prejudice.
Thank you, Your Honor. And I do
Okay.
have we of course asked for cost in this matter, given the fact that it's our belief this was a frivolous motion. I would of course leave that to the discretion of the court.
Now, at this time, the court will not grant any cost, but like I said, I'll dismiss it without prejudice. And Mr. Szymanski, I look for the order to be submitted to the court.
Thank you, Your Honor. We'll submit that today.
Thank you very much.
Very much, Your
Take
Honor.
Take
Good
care,
day.
gentlemen. Give me 1 second, Ms. Clifton.
Stacy Jabori, can you unmute for me? Which case are you on, please?
I am here for Progressive on Stringer versus
Stringer.
Progressive. Yeah.
Okay, very good. Thank you.
Mhm.
They don't have a settlement conference too. They just have the MSD, right?
Who, Judge? Stringer?
Stringer.
Stringer is just a motion.
Okay. Okay. All right. You can let him in.
Judge, can you check your chat, please?
Okay. Mm. 1 second, please. Hmm. Mr. Peters. Okay.
Thank you.
Mm-hmm.
So we're ready on Stringer?
Yes.
Long day, Judge.
Yeah. Welcome back again, Mr. Crawl.
Yeah. I want to make this easy on you. I'm sure
Okay.
all the lawyers been blowing hot air, yeah.
Okay. Ms. Clifton, when you're ready.
This is case number 250050047 NI, Jawan Stringer versus Tamika Springer et al.
Council appearances.
Tom Crawford, the plaintiff.
Stacy Jabouri for defendant progressive.
Your Honor, Thomas Assorti on behalf of the individual defendants.
Okay, thank you. Mr. Crawl, is there anything you said you're gonna make it easy? Is there anything you can do, or do we need to go forward with the motion?
No, I mean, I think everything's spelled out in the brief. I mean, we'll just, it's you understand my client did not sign anything and he is a named insured. So that's the only issue.
Mr. Bory?
Plaintiff elected out of the PIP benefits. I mean, I think it's again pretty simply laid out in the motion and the reply brief. The consideration for that was the reduction in the deductible that would have been paid per the affidavit that was attached. So, and I think someone knows the difference between what insurance is with the PIP on there versus without the PIP on there, just as presented in what they pay every month. So I'll just leave it at that and then rely on the briefs. I think it was pretty well laid out by both parties.
Right, it's very clear and concise. And even taking evidence that might most serve to non party, the court is satisfied. And the court will grant the partial summary disposition as it relates to the PIP benefits. The PIP benefits are excluded, as we know. The premiums would have been substantially higher had the parties not opted out, and by doing so, she would have had, paid that substantial amount to have that $250,000 coverage. That being said, the court is going to grant the partial motion for summary disposition. I think that's the only thing we had up on this case today, correct?
I think the part of the motion was also the uninsured, underinsured motorist.
Oh, that's right.
Part of
Yes,
the claim.
yes. And there is no evidence that there was an uninsured, underinsured motors claim, Mr. Crawl. So the court is prepared to grant that as well. Okay.
Very well, Your Honor.
Okay, so Mr. Bory, just prepare an order indicating that the opt-out for the PIP coverage and the fact that the policy does not provide an uninsured, underinsured motors provision.
I'll have that submitted to the court today. Thank you.
Okay, all right, thank you all.
And Judge, I just saw on the website you are the chief civil presiding judge. Is that what I understand?
I don't know what I am. I'm just here working. I'm just
That's what it's indicated on the website.
I'm just trying to handle and do God's work for the rest of my tenure here. I'm just
Well, congratulations.
no, it's no congrats. I'm keeping my head down and just working hard, working hard.
All right, thank you, Judge.
Thank you all. Take care.
Thank you.
Have a good day.
Bye-bye.